My lord, we have two IAs, my lord. My lord, there is some confusion, my lord, with regard to the cause title. What happened, my lord? Here we wanted to implead two respondents as respondent number 14 and 15 in the main writ petition, my lord. And as such, we have preferred these two IA. One IA is for impediment to the writ petition, and another IA is impediment of these two respondents in the IA, which we have filed. Now, my lord, on earlier occasion, Lordship has raised an issue. Yes, my lord, that case, my lord. Now, my lord, my humble submission before your Lordship is that when we file an IA, my lord, kindly come to the cause title. How we prepare it, my lord. Lordship is taking up which IA, my lord? IA number?
743.
743. Okay, my lord. So I am taking up 743, my lord. Now, my lord, what we write, my lord, in the matter of we file what is this interlocutory application for. Then we write, and in the matter of petitioner's name, we write this is the petitioner, means he is a petitioner in the main case, the writ petition, or the IA. Then, my lord, we write versus. We mention the parties which were there, 13 parties we have mentioned. They are the respondents in the main case. And then again, we bring up, my lord, and in the matter of, now he is an applicant, my lord. Kaushik Das comes as an applicant here. Versus we write, my lord, we have mentioned all the 13 respondents who were there in the main case. Along with that, my lord, we have also made 14 and 15 a party because we want to impede them. Now, my lord, Lordship had raised an issue, my lord, on the last occasion that why we need up to 13. This 1 to 13 need not be made a party. Since we want to impede only 14 and 15, so 14 and 15 has to be a party here. Now, my lord, this specific IA, my lord, which we have filed, this 743 is for impediment of 14 and 15. Now, my lord, here we have made 1 to 13 also a opposite party here, my lord. My lord, we have been doing here, my lord, this is a usual course of practice which we have been doing. And my lord, the reason behind that is that, my lord, now when we want to impede 14 and 15, 1 to 13 might have a say. And my lord, 1 to 13 are the main litigants. In the writ petition, they are the main litigants, my lord. They are contesting against us. Now, my lord, if we come up with an IA, whatever IA, my lord, be it for impediment or be it for something else, if we don't make them a party, then, my lord, it will be playing behind their back, my lord. Now we want to impede 14 and 15. Now, my lord, they may come and say that this is our delay tactic or something, whatever it is, my lord. Any sorts of objection may come. So, my lord, only to give them an opportunity to have their say, my lord, in this IA, we have made them a party. So 1 to 13 is there, and 14 and 15, because 14 and 15 will come up before this court and they may say that we are not a necessary party. Although the applicant is saying that we are a necessary party, we need to be impeded, but we are not a necessary, they will have their say. And, my lord, equally, my lord, since they are the main party in the writ petition, we cannot come up with any IA or any petition, my lord, behind their back. They necessarily has to be a party. Now, my lord, Lordship has mentioned about that, my lord, system, my lord, that having some problem, my lord, with the system, my lord, new systems are coming up, my lord, we understand. But, my lord, system has to go according to us, my lord. We will not go according to the system. Software has to change, my lord. Because, my lord, we cannot stop them to object, my lord. They have every right to object this IA of mine, my lord, which I have filed, my lord. So that is my submission.
Appearing on behalf of respondent, one personal dependent, we have already filed our affidavit. We have no objection. If they want to impede PNID, I think PNID is part. We have no objection.
No, you take your seat. That's not the question. Is not whether you have objection or not. Question is on a.
Saying the government might have any objection.
For this case, my
Mr.
lord,
Khan, your submissions look very attractive, but it cannot be accepted without a report from the registry. The reason is as follows.
My lord.
You want an order to be passed by impleading two opposite parties. Correct?
Yes, my lord.
So, insofar as your prayer in the IA is concerned, this is against the opposite parties. The opposite parties you want to implead.
14 and 15, yes.
No IA is ever listed without the connected writ petition. So, whenever the writ petition is listed, the other respondents are always present before the court. So, if they want to raise an objection, they can always very well do it. But a respondent cannot oppose the impleadment of another respondent, another person as respondent, if the court feels that this impleadment is necessary on the ground stated in the IA. This is reason number one why your argument cannot be accepted. Secondly, I have seen petitions where the applicants already implead them as respondent number so and so. They are shown as respondent number so and so. Say you want to implead two opposite parties as respondent numbers 14 and 15. It may or may not be the case in your case, but there are other applicants coming in. They are shown as respondent numbers 14 and 15. So that means whether the court passes an order, according to you, they have already been impleaded. So tomorrow, for some reason, if the court does not allow, then what happens to respondent number 14 and 15? 14 and 15 is already in the system. There is no guarantee that the court will allow it. Normally the court does. Supposing the court dismisses your writ petition.
My lord.
By that time, respondent 14 and 15 are already in the record. You have already impleaded them. The court has rejected your player for impleadment. Tell me what is the mechanism to delete their name as respondent number 14 and 15 as per your understanding. You must first argue on that.
My lord. My lord, what happens, my lord? Suppose we file a writ petition, my lord, with 13 respondents, my lord. That writ petition is filed, my lord. It is on record. Now we cannot, my lord, add any party, any respondent to that writ petition, my lord. Suppose my main writ petition, I can, if there are 13 respondents, it is 13. 14 and 15, I cannot add, my lord. In that, I cannot go back to the writ petition and add it, my lord, either by hand or anyway, my lord, without the order of the court. Now, my lord, for that order of the court, we are filing this IA. And what is our prayer in the IA? That the opposite parties, number 14 and 15, may be added as respondent number 14 and 15 in the main case. So, my lord, in doing so, my lord, we are not bringing in them, my lord. We have not stated, they are not mentioned as respondent.
It may not be in your case. In some applications,